I've got a special treat for all of you. I've been wanting to give an update on the Supreme Court case of Mahmoud versus Taylor, in which some Maryland parents sued the local school district over some children's picture books. And what better place to give my update than the Supreme Court of the United States? My family is here for vacation, and I've never been to DC, so this has been really, really exciting for me. It's the Smithsonian! It's the Enterprise! It's R2-D2! It's a Spartan helmet. It's a literal actual X-Wing. And R2-D2's in there. That's the Apollo 11 command module. That's Neil Armstrong's spacesuit. The ruling came in three parts. The first was the majority opinion, which was written by Justice Samuel Alito, and that focused on the technical reasons for why the court ruled the way it did. The second part was a concurring opinion written by Justice Clarence Thomas, and that covered more of the philosophy of education behind why the majority came to the opinion that they did. And the last part was the dissent, which was written by Justice Sonia Sotomayor on behalf of three of the justices. So what was in this thing? Let's find out what it had to say.
For reasons that will become obvious soon, I was unable to finish recording this outside.
Mom, it's really hot.
You're right, it is really hot here. No wonder politicians are so cranky.
So now I'm back indoors, where there's air conditioning. Oh, and before we dive in, I just wanted to give my standard disclaimer that I am not making any comments on anyone's personal beliefs or the way they choose to live their lives. I also wanted to thank all of you for how kind you were on my previous episode on this topic. I really was nervous to talk about it because I am afraid of online activists and what they might do to me and my family if I say something that they don't like. But it was my hope that if I approached this in good faith and just tried to be fair and analyze the facts, that I wouldn't attract any attention from the kind of people who like to be mean online. And that does seem to be the case, and I just wanted to say thanks to all of you for being so kind and supportive, and it gave me the confidence to follow up on this topic. Just to freshen our memories, Mahmoud versus Taylor was the case where some parents in Montgomery County, Maryland, sued their local school district because the school district had made some LGBTQ plus themed books a mandatory part of the English curriculum, not allowing parents to opt their children out, even if they felt that the lessons being taught around the books violated their First Amendment religious rights. If you want to know what was in the books, you can check out my previous episode. Supreme Court rulings are pretty lengthy, and I'm not a lawyer, so to keep this focused, I'm just going to talk about the parts of the ruling that address the books themselves and the rights of the parents. And to keep things light, I'll once again be using memes, this time from the West Wing.
Did you get the popcorn?
The final case wasn't settled in June. The Supreme Court only had to decide if the parents could have their opt-out rights back as this case proceeds through lower courts. The court agreed with the parents, and I'm not surprised.
Victory is mine! Victory is mine! Great day in the morning, people! Victory is mine!
I reviewed all 9 of the books, and I felt that 6 of them were of poor literary and artistic quality. 2 were so-so, and only 1 met the high standard for books that belong in an English curriculum. The books had more in common with Bible readers than literature, preaching a gospel of gender-neutral bathrooms, child gender transition, choosing custom pronouns, and progressive political activism. It's totally legal to write books with these themes, and it's totally legal to purchase them or read them. But it wasn't legal for the school to make them a mandatory part of the curriculum and then tell children that the ideas they included were the right ones, even if those ideas conflicted with constitutionally protected religious beliefs. The Montgomery School Board was heavy-handed in its policies and even made public remarks insulting the parents, the students, and their beliefs.
Just stand there in your wrongness and be wrong and get used to it.
The majority ruling written by Justice Alito rejected Montgomery County's claim that this curriculum was simply about showing children that there are people from many different backgrounds in the United States. Alito pointed to instructions in the English curriculum that told teachers that they should tell the students that they had harmful beliefs if they disagreed with what was in the picture books. Alito noted that members of the school board called sincerely held religious beliefs dogma that parents taught their kids to parrot. School board members publicly called the families xenophobes and compared them to white supremacists, which was an interesting strategy because the curriculum was pretty dogmatic and lots of the parents are non-white immigrants.
This is how trouble starts.
Alito's ruling gave detailed examples from 4 of the picture books in question: Prince and Knight, Uncle Bobby's Wedding, Intersection Allies, and Born Ready, to demonstrate that these books aren't just showing people who exist in society, but that they're designed to tell children what to think, what to say, and how to behave. He included images from the books that directly supported the points he was making. I'm not a lawyer, so I don't know what a court ruling is supposed to sound like, but from the standpoint of an essay, I found Alito's writing to be excellent. He's detailed and precise and supports all of his claims using evidence. I think high schoolers would do really well to read this just so that they can improve their own essay writing skills.
Attaboy. Can I have a cookie? No.
Alito returned opt-out rights to the parents, saying that they had demonstrated that their rights had been violated and that they were very likely to succeed when the final court case is heard. The second part of the ruling is a concurring opinion written by Justice Clarence Thomas. If any of you are lawyers, maybe you can explain why judges would write a separate essay agreeing with the main ruling. Like, is this just a thing where lawyers like to hear themselves talk, or is there a technical reason they do this? Justice Thomas didn't talk about the books themselves, but more the philosophy of why the court ruled the way it did. This is well out of my depth, so I'm not going to get into it, but if you're interested in sort of the case law behind this, you might want to look into a case called Wisconsin versus Yoder, because that's the one that came up the most in arguments, and it's what the parents relied on to argue their case. The shortest way to explain Wisconsin versus Yoder is that the Supreme Court ruled that it's not the place of the government to rescue children from parents who have beliefs that some people might find weird or objectionable. As long as you're following the law, you're able to live your life the way you want to. After all, this is America. We're allowed to be as barbaric as we want. Yoder established that the purpose of education is to prepare kids for meeting the duties of citizenship. I love this definition of education because there are so many different ways to prepare children to meet the duties of citizenship. Some subjects really are essential for everyone. If you can't read, write, and do math, then you're going to have a very hard time functioning in society, whatever you choose to do in life. But beyond that, quite a lot of things are optional. Marching band, French, graphic design, nihilist Russian literature, also known as Russian literature. Thomas argued that when it comes to curriculum about gender identity and sexuality, quote, there is little to suggest that these lessons are critical to the student's civic development, end quote. If you believe that lessons teaching third graders that they should choose custom pronouns and swap them out frequently is essential education, that is your right. But you should also know that the law doesn't really support that, and there's also very little social support for this idea. You can be totally committed to a cause and recognize that not all advocacy is good advocacy.
Don't get hostile. I don't get randomly hostile. I get hostile when hostility is called for.
In this case, the curriculum that Montgomery County adopted violated the constitutional rights of parents, and then they just doubled and tripled and quadrupled down instead of coming up with a better strategy. They played a silly game and they won a silly prize.
I believe we can find the door.
Whether or not you agree with Clarence Thomas's concurring opinion, I think it's worth reading because it's an elegant, logical piece of writing that really flows beautifully through its argument. As with Alito's ruling, older teenagers could benefit from reading it to strengthen their own essay skills. This brings us to the dissent, which was written by Justice Sonia Sotomayor, with Justices Kagan and Jackson joining in. I found the tone and style of the dissent to be very different from the ruling and concurring opinion. Sotomayor refers to herself in the first person. This seemed oddly personal to me, but again, I'm not a lawyer. If you know anything about this, let me know if that's unusual in a court ruling. Sotomayor also got a little hyperbolic in one or two places. This did make her writing harder for me to take seriously, although it was more fun to read. She tried to argue that the books were being treated unfairly, saying, quote, exposing students to the message that LGBTQ people exist and that their loved ones may celebrate their marriages and life events, the majority says, is enough to trigger the most demanding form of judicial scrutiny, end quote. But most of these books really aren't just an acknowledgement that different types of people exist. As I noticed in my own review of the books, and as Alito pointed out using evidence in his ruling, they're making very specific moral claims and encouraging children to adopt certain beliefs and behaviors. Sotomayor then gives what I would classify as a lousy book report.
It's going to be an unbearable day.
She summarizes Uncle Bobby's Wedding without offering any commentary on the text, accuses Justice Alito of misrepresenting the book in his ruling, and then includes a copy of the entire text as an appendix and said, read it for yourself, instead of explaining why it was good enough to be mandatory reading in school. Your Honor, this bugged me for 3 reasons.
Well, you go, girl.
When I reviewed the 9 books involved in this court case, I felt that Uncle Bobby's Wedding was the best of the bunch. It was the only one that was child-centered, age-appropriate, and of high literary and artistic quality. So it was smart for Sotomayor to focus on it, but she cherry-picked big time. The other 8 books were pretty low quality, which is 88.888888%.
I can still flummox this thing with something I bought at Radio Shack.
The second reason this bugged me is just because I'm a book person and not a legal person. Legally, this is probably totally irrelevant, but I didn't like the fact that she copied the entire book into her dissent. Sotomayor gave a pretty thorough summary of the book, so why did she need to include a copy of every page, especially given that she didn't even offer any commentary on the text? Alito included selected images from the books that were relevant to the points he was making. To me, as a book person, this is fair use of literature to make a point in an essay. I'm sure since Sotomayor is a literal, actual Supreme Court justice, she understands the law here, and it must have been legal for her to include an entire copy of the book and then upload it to a government website where anyone in the world can now read the text of this book for free, but under any other circumstances, this would have been content theft. So I fully acknowledge my limitations of understanding on the law. Maybe there's a perfectly good legal reason why this needed to be included, but I care a lot about authors' intellectual property rights and fair use of literature. So just purely from my biased standpoint as a book person, I just wasn't very happy about this.
You can't do that.
Why not?
Because it's freaking me out.
The last reason I'm weirded out by this pirated but not pirated copy of Uncle Bobby's Wedding is that for some reason, when it was uploaded as evidence, they used the British edition of the book and not the American edition, which would have been the one that kids in Montgomery County, Maryland, USA, would have been reading. I have not been able to discover why the wrong edition of the book was used in the court case, but luckily there were only some spelling and vocabulary localizations. The overall story is the same. Still, it seems like a pretty big mistake to upload the wrong version of a book in a Supreme Court case. Like, what if there had been some changes to the text that affected its meaning or the way the words were used that were relevant to the case? Like, this could have really undermined the whole proceeding.
I'm gonna get fired.
Nobody's getting fired.
I'm the new guy. I'll be made an example.
So that's what's in the ruling itself. But now what a lot of people are wondering, especially since school is starting, is how is this ruling affecting not only the parents who are in Montgomery County, Maryland, but also parents all over the country?
In her dissent, Sotomayor predicted that if parents had their opt-out rights restored, the result would be, quote, chaos for this nation's public schools, end quote. I'm currently recording this in August while I'm visiting Washington, D.C., but I thought I would check in with my future self who'll be editing and publishing this episode after school's been in for about 6 weeks. Future self, how are things going? I've been on the lookout and there are no signs of chaos in our nation's schools. Oh, not even a little chaos? Not even a little chaos. I've been able to find some small anecdotal evidence that parents are using the opt-out forms that are now enabled by Mahmoud versus Taylor, but I can't find any reports of chaotic environments being created at schools or school districts suddenly being unable to cope with a sudden flood of opt-out requests. What's the weather like back home? Because I gotta say, when they call this place a swamp, they're not joking. It's cold and wet and rainy. Sotomayor also said in her dissent, requiring schools to provide advance notice and the chance to opt out of every lesson plan or story time that might implicate a parent's religious beliefs will impose impossible administrative burdens on schools. Will it though? All the schools have to do is just not violate the Constitution. They need to be, let's see, what's the word that I'm looking for? Inclusive. They need to be inclusive of all constitutionally protected beliefs.
Are you mocking me?
No, sir.
I'm sure we all remember that Calvin and Hobbes cartoon where Calvin tries to get out of doing a math problem because he claims it violates his religious beliefs. Calvin's claim is absurd, and a school wouldn't have to take it seriously. Parents are busy and tired, and most of them aren't crazy. They're not going to spend all day scrutinizing curriculum and objecting to every tiny little thing about it. People who are already that worried about public school curriculum have either pulled their kids out to homeschool or they've sent them to private schools. Sotomayor worries about classroom disruptions and absences, which can be harmful to students' learning. But schools are already set up to deal with the fact that some kids need to come out of some lessons for certain reasons, sometimes for therapeutic reasons, sometimes for personal belief reasons. This is not a new thing, and it's really not that hard to implement. Sotomayor said, quote, "The majority closes its eyes to the inevitable chilling effects of its ruling. Many school districts, and particularly the most resource-strapped, cannot afford to engage in costly litigation over opt-out rights or to divert resources to tracking and managing student absences. Schools may instead censor their curricula, stripping material that risks generating religious objections." The money is actually a good point. Montgomery County has already spent over $2 million on this court case. Think of how many music programs that could have funded, how many computers it could have bought, how much sports equipment.
Does anyone think that raising awareness of crumbling schools won't help us?
I also bristle at the word censor. I feel like I'm just repeating myself at this point. All the schools have to do is not violate the First Amendment. You can absolutely teach about all kinds of different people. Just don't tell children what they're supposed to believe or what kind of political activity they're supposed to engage in. It's not hard.
Oh, God, I'm sorry. Am I still here?
I've been watching this story pretty closely, and I can't find any evidence that this is really causing that many ripples. Again, other than the opt-out forms that I've seen circulating from some law firms and parents groups, I really can't see any evidence that this is adversely affecting schools in any meaningful way, and there certainly hasn't been very much reporting on this topic at all. I will continue to watch it, and if you've noticed anything in your local area, maybe let me know about that, because then we can gather some more information. It's all anecdotal at this point, but it would be interesting to see if there are any truly chaotic or disruptive situations that result from this, or if this is just going to kind of continue the long tradition that American parents have of being able to opt out of certain lessons that touch sensitive areas that they would just prefer to address at home in a way that's consistent with their beliefs and values.
What's next?
I hope I've been able to stick to the facts here. I really do mean it when I say I just want to call things fairly. I do think Montgomery County made some pretty big mistakes, and for reasons that I can't understand, they have just continued to dig in their heels rather than reevaluate their strategy. I want all Americans to get along in a tolerant civil society, and I don't want anyone to be mistreated for who they are. But this court case is an example of how not all advocacy is good advocacy. I think Mahmoud versus Taylor has hurt the LGBTQ+ movement because the school district was pushy, preachy, and unapologetic about the way it stepped on parental authority. In the past, screaming, "Repent, sinner," didn't turn gay people straight. And in the present day, screaming, "Repent, bigot," isn't going to convince people to join your political movement. I'm sure the response of some people to hearing me talk about this is, "What do you know? You don't even have a law degree. You're just some dumb housewife." And that's true.
I'm sorry to be rude, but are you a moron?
In this particular area, yes.
I'm just coming at this from the point of view of a normal person who wants to try to understand how educational policy and the law intersect. Cases like Mahmoud versus Taylor have a massive impact on how much parents trust schools and how much confidence they can have that when they send their precious kids out to school, they won't be taught things that violate their deeply held and constitutionally protected principles.
The whole system's gotten out of hand.
Yeah.
So where we're at now is that in the United States, parents now have the right to, if they wish, write a letter to their child's school and say that they do not wish for them to participate in lessons that address LGBTQ+ themes. Instead, the child will be given an alternative activity that still supports the technical requirements of the lesson, say vocabulary development or story analysis, but not using subject material that the parents feel might interfere with their ability to direct the moral, religious, and cultural upbringing of their child. I do think this will affect how school districts select books for their English curriculum. I wouldn't want them to take this case to mean that they shouldn't include books about diverse groups of people, because nobody wants that. Of course, we want to learn about people from all kinds of backgrounds. But what I hope Mahmoud versus Taylor does is just remind school districts that might maybe have some activists in their ranks that you can't privilege one constitutionally protected set of beliefs over another. You have to be ideologically neutral and inclusive of children of all backgrounds, even if you disagree with what their parents believe.
So that's how the ruling for Mahmoud versus Taylor went, and that's how it's going to affect teachers, students, parents, and curriculum in schools. And as you can tell, my family is very excited to get out of this heat and move on to the Capitol for our tour. So now I will leave it to you. What do you think about this ruling? Do you think people have been hysterical or dishonest or right on the money in terms of their commentary about this case? And how do you think it's going to affect your kids in your state? I'd love to hear from you. Let me know.